ear or burn their place down or drop the F-bombs or, you know, the other things I've seen, because that's not going to impress a court when the tenant shows up with all those in printed form and says, this is the landlord I've been dealing with, okay? You have to make the court want to rule in your favor too. So when you're writing something and you're communicating with your tenant, always, always keep in mind that you are also writing something that a judge is going to see someday, right? Whether they do or not, always practice that. Be timely in your response to those requests. Obviously, that's kind of a no-brainer, but it can bite you. I don't like to use 10 days. 10-day notices are weak. They can be beaten with substantial compliance, as opposed to the 3 days or the 20 days, which require strict compliance. So at any chance you can, some of this requires documentation in your contract up front. For example, trash is a big one, right? Or yard maintenance is another one. The tenant's responsible for picking up the trash and keeping it clean, or tenant's responsible for maintaining the yard. Have a clause in there that says if they don't do it after notice, that the landlord has the right to do it and bill it to them if they don't, right? Because then rather than going and having a 10-day notice that says, go mow your grass, and they don't, but they went out and started trimming it, maybe got a little bit of it, that could be substantial performance that could make you lose that case. They started. You know, money's digital. I went out and did it, I incurred a cost, I gave you the bill. You either paid it all or you didn't. There's no ambiguity. You give them a 10-day notice for money, it's not easy to defeat. It is very digital. It is what it is. So much stronger way to go forward on a 10-day like that. Yes, sir?
For assured properties, can you have a clause in there that says patients left unattended for more than, say, 4 hours they can dispose of?
Boy. That's a good question. I think a lot of that's going to depend on the circumstance. It's going to be very fact-based. The question was, can you have a clause in your contract that says something to the similar to anything left unattended for 4 hours outside can be disposed of? You know, again, I think that's going to be fact-specific. If it's refuse, probably no problem. If it's personal property, then the court always has the out of saying it offends the conscience of the court. They can always void a portion of the contract by saying it's contrary to public welfare of the public and it offends the conscience of the court, and they can undo it. So, again, very fact-specific. Yes, ma'am?
So if you, for example, had in your contract that no personal items were allowed in their personal parking space, could you then go...
Other than an automobile, you
Other
mean?
than an automobile.
Yeah.
Could you then go to the people that do have personal junk in their parking space and say you have, for example, 48 hours to remove it?
No.
Or it will be removed?
You'd need to do that with a 10-day to comply.
A 10-day.
Yeah, any attempt to enforce an area of the contract or a behavior of the contract that isn't payment related, rent payment related, or termination has to be done on a 10-day notice. But if it's in your contract that they can't do it, you most certainly can give them a 10-day. But again, if you had something that said, or it'll be removed and put in storage at the tenant's expense, then you could do it if they didn't. And then if they did, it's very digital, right? They've got an expense they've incurred, they either paid it or they didn't. If they go out and get half of the junk out there, for example, after your 10-day, then they may have substantially complied and you can't act on that 10-day. So that would be another example of how you'd want to try to convert it to a payment situation rather than enforcing behavior. Very difficult to get an eviction on enforced behavior. Notices, moving right along. I hope we're not late. No wiggle room. Okay, notices are the part that the landlords can do by themselves, and they're the most complicated, most difficult, most or I should say least forgiving, no mistakes, strict compliance on these, okay? I practically give my notices away because I see so many people that have messed them up the way they've delivered them or filled them out that I have to start them over all the time, and it breaks my heart. I'd rather just do it right in the beginning. I can make mistakes or have wiggle room on the pleadings that follow afterwards. I've got more room on the summons and complaint, for example, to make a mistake or be not as accurate as I can be or whatever and still get away with it, okay? Not so with the notice. So make sure you know what your notices are all about. I've taken the time, if you're ever really insomniac and can't sleep, you can go to my website. I have videos I made. They'll teach you how to do notices right, both the delivery and filling them out, and how many you have to give and to whom, but it'll still put you to sleep. So, dual purpose. Address has to be complete and accurate. Make sure names are spelled correctly. You need to understand who your tenants are, okay? They're not always the people you started with, right? If you move in some guy who subsequently gets married and moves his wife in and you never took the time to, or a girlfriend for that matter, never took the time to add her to the lease, or they move on Uncle Bob, and at some point you have accepted Uncle Bob, you didn't act on kicking Uncle Bob out for not having permission, or maybe you accepted a payment from Uncle Bob, or something like that, okay? Those people potentially are your tenants, and they're entitled to their own copy of the notice. Now, that doesn't mean they're financially obligated. The names, one notice, in my opinion, the best practices, one original notice with all the names that are financially obligated on that one notice. That makes your declarations much simpler. And then if there's 3 people that are entitled to give it, you give 3 photocopies, 1 to each of them, or if you have to give one, all 3 to one and you mail the other 2. Or perhaps you post all 3 and then mail all 3. You're always better off doing one for all other occupants as well, okay? Yes, ma'am.
So each person doesn't need their each individual notice?
No, I don't like that, because then that means if you've got Tom, Dick, and Jane,
Yeah.
right, and you write one with Tom's name, one with Dick's, and one with Jane's, you've got at least 3 declarations of service that you have to complete. If you posted mail, you now have 6 declarations if it was done by 2 different people, okay? So your declaration requirements can get big and ugly fast, and that's the quickest way in the world to put doubt on your case, okay? If you did all 3 on one, then you've only got 1 declaration, or at most, if you posted and somebody else mailed, you'd have 2.
Is it mandatory to say all other occupants?
It's best practices,
Okay.
right? It's not mandatory, but it is best
So
practices.
you have 3 people, you put the names, all 3 names on the notice, and all other occupants?
Right.
And you add 1 notice?
Yes. Well, you have 1 original,
Right.
but you give 4 notices in that
Sure,
case,
sure, sure.
right? 4 posted, 4 mailed, 4 personally delivered, 3 mailed, whatever. But if you've only got 3 names on there, and there's a John Doe that you didn't know about living there, or a Jane Doe, when the sheriff shows up, the sheriff is not legally allowed to evict that 4th person. All other occupants covers your base.
Okay.
All right, you have to mail to your tenants, do it in their own separate envelope. Don't put all of them, right? Statute requires mailing by first-class mails. A lot of people want to do certified. You want to do certified, that needs to be extra. You need to have it go with just a regular stamp, okay? That's what the statute requires. I have seen cases defeated because they were mailed certified and not mailed with a regular stamp. So certified is for your benefit, or some contracts require it. But just because the contract requires it be sent certified doesn't make the statute's requirement to be sent regular first-class mail go away. Then you're obligated to do both. That's very typical in commercial contracts. So,
Is it a good practice to send it both ways and say, sent certified mail and by regular mail?
It's
And
not a
put the
bad-
number on there?
It's not a bad practice, yeah. It's not necessary. Your declaration that you dropped it in the mail in the county in which it was in should be sufficient, but it's never bad to have records.
Well, how do you even know they even got it?
You don't. It's not your problem whether they got it or not. Your obligation is to mail it. Whether they get it or not is their problem. The law doesn't require they get it, the law requires you send it.
So how do you document that you did?
A declaration. I swear under the penalty of perjury that on X date and time, I dropped this in regular first-class post. It's their obligation to prove that your declaration, and it's the obligation under a clear and convincing standard, was not accurate. Okay? So the burden of proof is on theirs to prove that your declaration is wrong. If you want to go a step above and add, proof of delivery or proof of receipt, that's fine. Yes, ma'am?
Yeah, I usually do a proof of delivery or proof of mailing, which
Yeah.
then they just stamp and you have a little.
Yeah, I like the proof of mailing too, because you don't have to prove they got it. Delivery is not necessary, just that you mailed it. That's another question. I'm out of time, I guess. Am I out or just getting?
No, you're out.
Have to knock first,